that it would be unconstitutional to grant an order of unsuspended committal in the context of motion proceedings if the committal is not aimed at coercing compliance with a court order. The minority's judgment agrees wholeheartedly that this court must defend its orders and authority, but stresses that it can only do so within the bounds of the Constitution. It warns that while satisfying an undesirable desire to address Mr. Zuma's scandalous disrespect for this court, an order of unsuspended committal would trample over the constitutional rights of alleged contemners, including Mr. Zuma. After surveying our jurisprudence on civil contempt, the minority judgment concludes the following. First, that civil contempt has dual remedial and punitive processes, with the main process of civil contempt proceedings being the enforcement of the court order, and that it had found no case in the history of our jurisprudence in which a punitive committal order had been ordered. Secondly, that the Constitutional Court had yet to consider the constitutionality of punitive committal orders in the context of civil contempt proceedings, but has concluded in respect of criminal contempt of scandalizing the court that a summary contempt procedure intended purely for penal purposes is inconsistent with the fundamental rights protected by Section 12 and 35, subsection 3 of the Constitution, because there is no interference in the judicial process or the administration of justice, which calls for swift remedial action. The minority judgments note that it is not enough to say, as the majority judgment does, that the contemner allows punitive committal to be ordered in civil contempt proceedings.